That's it. That's it. There you go.
Thank you, sir.
There you go, sir.
Thank you.
There you go, sir. It is. Big
May I
and-
get your autograph later since this is,
Big and colorful.
I don't think it merits an autograph.
All right, Mr. Chairman, if you want to call it to order here.
There we go.
I put in invocation and pledge. It's up to y'all.
I'm good.
The
I have
agenda,
it.
All good to move?
was this advertised,
Yes.
was this agenda advertised?
Well, yeah.
Okay.
But-
If there's no objection, is there a motion to amend the agenda before we begin?
so move,
I have a motion to amend the agenda, and
Yes.
what that way, Mr. Bryant?
to, not do the invocation and pledge in expediency of hearing the awesome presentation for tonight.
I have a motion to expedite the agenda by removing items B1 and C1. Do I have a second? I have a second. All in favor, raise your hand. All opposed, there is no opposition. The motion passes. We are amending the agenda. Item number D. David, would you make an introduction?
All right, I will. County Zoning Attorney Newton Galloway conduct a training session for Planning and Appeals Commission members concerning specific procedural requirements for zoning appeal cases to be heard by the same board at future meetings per Code Section 410.
Thank you. Mr. Galloway,
Good evening.
good
Good
evening.
evening.
Good evening.
We're gonna talk tonight about the responsibilities you have now to serve not only as the planning commission that you used to do and that you appointed, but also your responsibilities as the replacement board for the Spalding County Board of Appeals, which was dissolved back by ordinance in December, and also due to the application of the enactment of House Bill 1405 dealing with zoning decisions and responsibilities. So, we're gonna get started, and I'm sorry, I've been in a meeting for 3 hours, and I'm gonna undo my tie, all right. You're familiar, because all of you have been on this commission and had experience for several years and several terms with the requirements of the planning commission, what we used to call the planning commission, with regard to zoning and special exceptions. You did not have variance authority at that point. They were handled by the Board of Appeals, and you did not have authority to decide actions where the decision of the zoning administrator, the decision of the community development director, was the subject of complaint and criticism by an applicant.
Mr. Galloway, this is being recorded, because I did do this advertise this as a public hearing. Are you fine with that being on
That's fine.
the YouTube and all that?
That's fine.
Okay.
I assumed we were.
Yeah.
All right. Now, again, this goes back to House Bill 1405. 1405 passed, I believe, in 22 or 23, and it allowed an application for rezoning, which included a special exception or a variance, or both, or an application for a special exception, which also had a variance tied to it, to be considered as a zoning decision. And it is from that that we make the decision as to whether you are handling and in what capacity you are considering an application. So what I have provided you is a number of statutes that are applicable here, most of them coming out of Section 1405 amendments. And the first we're going to look at is OCGA 3666-3. Now, you have had experience, practical experience with the application of these texts in a number of recent zoning decisions that you are involved in, going back to the beginning of 2025. For example, the North Talladega Wilson Estate property submitted by Minerva included rezoning. It included to go to village node. It included special exception to allow active adult residential. It included a variance regarding certain setbacks. You heard all of that, so even though it was a variance, and even though it was included, and even though the Board of Appeals still existed, that came to you. Now, we're about to go into a legal esoteric discussion, but it's important for you to understand how you're fitting into this. All right. When Mr. Allen presents you with an application that includes a rezoning, includes a special exception, may include a variance, you are making a legislative decision. Now, where does that decision come from? Where's the authority for that decision come from? Under the Georgia Constitution, counties and local governments are given the authority to zone property. Those statutes and constitutional provisions also note that zoning is legislative. So when the Board of Commissioners is sitting and hearing your recommendation on that North Talladega application, or the last one at Wallace Jackson, which included a variance, a special exception for a data center, and rezoning to downzone the property, all of that is now a legislative decision, and when the Board of Commissioners is making that decision, they are sitting as the legislature of Spalding County. You are like a legislative committee making a recommendation to move something forward or not. Now, somebody comes in, and I'll use the last appeal that we had while the Board of Appeals was still active. Mr. Allen was asked to issue, I believe it was a business license for the forklift graveyard, or approval of the forklift graveyard in Sunnyside.
Yes.
The building had been sitting, you remember, for years. It was the forklift graveyard. And then the property was sold. The purchaser of the property operates essentially recycling businesses, which could include a number of things. But it sat. It sat empty for several years, or more than a year. It was a non-conforming industrial use in a commercial zone. Because it sat empty for that period of time, the protected non-conforming use could no longer be maintained. They applied for a business license. And David, what did you do on that business license based upon that?
Denied it.
Right, he denied it. So they filed an appeal to what was at that time the Board of Appeals under Section 410 of the zoning ordinance. Now, that's completely different from a legislative decision. And now that authority is vested with you. So when that application makes it up to the Board of Appeals, they are dealing with a quasi-judicial decision. So the same board now continues your authority over legislative decision recommendations, but now you are also the final determiner of an appeal from the denial of a permit or from some action, the refusal to approve a plan. The very last appeal that the Board of Appeals heard was the assertion that David had denied the demolition permit on the Williamson house on the McElroy rezone. Now, when you're sitting as a quasi-judicial body, the world is different. The hearing before you is different. And the impact of your decision is different and significantly impacts how the case proceeds if an appeal is taken. So let's look at 3666-3. So bottom line is, you are a body created by Spalding County, and you wear two different hats depending upon the capacity in which you sit and the nature of the application you're reviewing. So let's look at 3666-3, subpart 1.1. What is a quasi-judicial board or agency? Okay, now how's this for a circular definition? A quasi-judicial board or agency is any board or agency designated by ordinance to make a quasi-judicial decision. All right?
Right.
So what is a quasi-judicial decision? A quasi-judicial decision means final quasi-judicial action that is the exercise of quasi-judicial land use powers, including hearing appeals of administrative decisions and hearing and rendering decisions on applications for variances, administrative permits, or similar permits not enumerated herein as a zoning decision, pursuant to standards for the exercise of such quasi-judicial authority adopted by the local government. Such term does not include permits issued or decisions made by administrative staff, that's David, pursuant to the authority designated by ordinance, which contains an express right to appeal to a local government board or authority which is subject to these provisions applicable to quasi-judicial decisions. So, he is not performing a quasi-judicial decision. You are performing a quasi-judicial when somebody doesn't like what David has told them they cannot do. All right. Now let's distinguish that from zoning, and let's walk through, again, the summary I've already given you. Look at subpart 3. Zoning means the power of local governments, and I'm going to skip a little, to provide for the zoning or districting, you didn't know district was a verb, did you? Of property for various uses and the prohibition of other or different uses. Okay? Let's look at what a zoning decision is. Zoning decision means final legislative action which results in the adoption or repeal of a zoning ordinance, the adoption of an amendment to the zoning ordinance which changes the text of the zoning ordinance. Y'all see those regularly come through before they go to the Board of Commissioners. C, the adoption or denial of an amendment to a zoning ordinance. to rezone property from one zoning classification to another. That's what you are most commonly making a recommendation on. D, the adoption or denial of an amendment to a zoning ordinance by a municipal local government to zone property to be annexed into the municipality. You remember some years ago when an issue arose regarding what are now apartments located between South Pine Hill and Lenox Circle. E, the grant or denial of an application for a special use of property. That's what we call a special exception. And F, the grant or denial of an application for a variance or the imposition or modification of conditions concurrent and in conjunction with a decision pursuant to subparagraph C, that's a rezoning, or E, that's the special use permit of this paragraph, or a subsequent modification to such a variance or condition. So, if a property has come to you for rezoning and you impose conditions, or the Board of Commissioners imposes conditions, and somebody becomes dissatisfied with those conditions, or for a valid reason they need to be changed for whatever reason, that is a zoning decision in and of itself.
But not legislative.
No, those 5 things, or 6 things, Frank, are all legislative decisions. The imposition or the change of a condition is legislative. Now, so, you have very, very different roles when you are sitting as an true appeals board from when you have a zoning decision come before you. Now, let's test a little bit on your knowledge here. Variances are covered under section 411 of the zoning ordinance. Some of you have been on the appeals board, all right? Somebody comes in with a variance and they're making a request to have a side yard changed or this changed or whatever it is. Okay. We used to have criteria based solely on hardship. And there are a list of criteria that are in the ordinance. For a standalone variance, that is still true. When I say a standalone variance, I mean a variance that's going to come to you just as a variance. It's not tied to anything else. Now, let's look at what I just read in 3666.3.4. Is a standalone variance that comes to you legislative or quasi-judicial? Standalone variance is quasi-judicial. Why?
Well, I guess because it's varying by that name of variance.
So you are not changing what underlying that variance.
But you wouldn't be changing the zoning.
That's
You're
correct.
just, I guess fulfilling or deny or approve what they're asking for based off of.
And
Correct.
the variance is
Criteria.
never on a use, it's a standard of some
correct.
setback or size
correct.
or something.
In
And
fact, Georgia law provides, case law provides, and this is pretty standard, a variance cannot be approved that changes the use of property from that allowed in the zoning district. Now, there are some quirks in that. For example, in David's home county and Pike County, they have within their zoning ordinance catch-all provisions that say any use that is not allowed in this district may be considered as a special exception use based upon certain criteria.
If it's prohibited,
I'm sorry?
even if it's prohibited?
Yes, sir.
Oh,
Well, it's not technically prohibited,
Yeah.
Frank.
Look,
It's just not expressly
it's not
allowed.
mentioned.
Not expressly allowed.
Right, right.
All right, so, but now, let's go back and let's look at the last data center, which is Wallace Jackson. All right? In that case, there was a variance request, and I might add, we have always been very, very liberal in allowing people to make requests for variances. Taking the position it's their property, if they want to ask for it, they can ask for it. It's up to y'all to decide, and the county, well, for y'all to decide a standalone variance, or for the county commission to decide the application to a variance that is included within a rezone. But our ordinance on standalone variances, David, tell me if I'm correct, still has criteria for the application of the determination of whether you should approve that variance, because the variance on the standalone variance stops with you. When was the last time you had a standalone variance?
Oh,
A month ago.
so the question though, right, in our applications, the V designation, is that,
There, that's variance.
okay, all right.
All right, so when's the last time y'all had a true standalone variance?
Well, I mean, going by that
Last
application,
month.
it was last
From
month with that
last month.
separate action item.
What was it?
For allowing
The
the
little
data
corner
center
property?
on the
Nope,
property.
not the data center. No, ma'am.
The property where they wanted to offset go in and put the other property down, it was
Yard
variance
limitation.
front or back.
New cold height.
Yes, correct, the height variance.
New cold
Oh.
height.
Okay.
Yes.
All right? Now, you also had a variance in the data center. Do y'all remember what the variance was for? In Wallace Jackson, what was the variance for?
To allow a data center,
I'm sorry?
to allow the data center.
No?
In the S2 and
Yes.
S4.
The S2.
S2.
The sliver of property was in S2, and the ordinance said it cannot be allowed on a parcel that's within the watershed. But that was within and conjoined with a rezoning application, a special exception application, and then, of course, that variance was attached. So the rezoning application was what type of decision? Your recommendation or the Board of Commissioners, the determination,
Legislative.
legislative. The special exception to allow the data center as a special use in C1C?
But that'd be legislative
That's
too.
legislative under section E.
Okay.
So then the variance is attached, and in that case, the variance is,
That'd be the quasi.
nope.
It's
Why?
also legislative.
It's a zoning decision because the statute says it's tied to a rezoning
Uh-huh,
application.
okay, all right,
Bundled
So the
together as
same
legislative.
Okay.
basic kind of request,
right.
the same variance is either legislative when it's tied in to a rezoning or a special exception. It's quasi judicial if it's standalone. So on the same agenda, because I think they were both on, I think Wallace Jackson and New Cole were on the same agenda in front of you.
Right.
So the variance request for New Cole is quasi judicial. The variance request for Wallace Jackson is legislative. So the New Cole variance proceeds under section 411. But 411 has a provision that says a variance that is tied into a rezoning or a special exception is legislative and is not handled under section 411, it is handled under section 414. So it is reviewed as part of the rezoning. Yes, sir.
So if they had not done that, and they came back subsequent to then and said, hey, we would like a variance now because we've discovered this, then that would be purely the
Quasi-judicial.
quasi-judicial,
It
because
would be
it's
a standalone
separated
variance at
from the
that
reason.
time.
Okay, thank you, thank you.
At least that's the way I read the statute bill, and
Okay.
guess what? There have been no decisions under these new definitions and
Gotcha.
new divisions between what
Okay.
constitutes a zoning decision.
You,
Yes, sir.
while we're addressing that, there was the issue of the FAA approval. And I had talked to Croy, Engineering, and asked them about this, and she gave me the form number that was supposed to be filed. And it's supposed to be done before they start construction. But their answer was, well, once they get cranked up, they'll check.
You're talking about new code?
Yeah,
Okay. All right, let me make a disclosure. Y'all remember I had to recuse myself in that case.
Right.
The reason is because I had represented them on a similar application in Locust Grove.
In the Henry County facility.
Well, they were looking for another Henry County facility.
Okay, all right, got it.
All right,
Okay,
now.
well, and
what-
thank you for
What
doing
about
that.
the
That's-
FAA thing, Frank? Now finish that
well,
up.
what I'm saying was that when you approve a rezoning and everything else except they haven't gotten FAA approval, it looks to me counterproductive, because you're going ahead and approving some stuff, and yet if the whole thing is being done to build that with a 140-foot structure, and if FAA says, no, you can't do that, and a good example of that is the FAA has not decided specifically which tracts of land they're gonna take. I mean, they've identified some stuff that they said, well, we may come get you, we may not.
All right, hold
Yeah,
your
but-
question,
yeah,
because I
yeah.
want to walk through it with you.
Right,
If that had come to you as a if that had come to you in the context of a rezoning, you would be looking at it solely from the context of land use. All right? The variance is not tied to another agency's administrative decision. All right? And we don't have authority until FAA will make the call whether this violates some height requirement or some lighting requirement. All right. So, I would argue, in that case, that is not a relevant consideration to determine whether a variance should be granted.
Okay, all right, that's all I need to know, thanks.
Now, that said, anytime you have a crowd that's opposing the development of some sort, people are gonna raise those questions. And then whoever's making a decision is gonna be accused of not following those procedures, all right? Now, yes, sir?
well, I'll just add when you're done, so.
Now, we had a similar agency issue, Frank, not on New Cole so much, but on Wallace Jackson. Now, what's the general rule on the applicability of a new regulation? How does it apply?
You
To
mean
what
like
does it apply?
To any action taken
Anything after that?
After the ordinance.
It has- the
After the
ordinance itself has to
regulation is
be-
passed,
Right.
okay?
Can't be retroactive, no.
Well, there's a standard for it being retroactive. But as a general rule, Frank, the answer is no, it can't be retroactive. With the data centers, and it wasn't just Wallace Jackson, it was all the rest of them, ECA, which is responsible for developments, their agencies are responsible for developments of regional impact, had made no decision on whether a DRI was required for a data center. They didn't have a definition of a data center. So, the applications that David handled, or that were submitted to David, not just at Wallace Jackson, but the other one's at Tomachichi, I believe, in 16. And then
Yes.
there's one that's off High Falls on Alan Mobley's old residential property.
Mm-hmm.
When those were submitted, there was no DRI regulation. There was nothing that said it had to go through DRI review. So Wallace Jackson is filed in October, I believe. That's close, isn't it, David?
Yeah, that's about right.
They issue a DRI decision on how to handle data centers. Wasn't it December the 15th? We were already scheduled for hearings,
Something like that.
okay? And we were on the phone New Year's Day with Three Rivers because they were demanding that those applications receive DRI review. Yet it was a retroactive application back to an application that had been pending for 2 months. All right. Now, so having talked about legislative and quasi-judicial, let's move to OCGA 3666-4. Hearings on proposed zoning decisions. Now that would suggest that this section has no application to an appeal from a decision that David makes that somebody is dissatisfied with. But let's look at 3666-4A. A local government action resulting in a zoning decision shall provide for a hearing on the proposed action, where the proposed action includes any combination of zoning decisions under subparagraph C, that's rezoning, E, special exception, or F, a variance tied to a rezoning, of paragraph 4 of Code Section 3666-3 for the same property, only one hearing shall be required under this code section. At least 15, but not more than 45 days prior to the day of the hearing, the local government shall cause to be published within a newspaper of general circulation within the territorial boundaries of the local government a notice of hearing. The notice shall state the time, place, and purpose of the hearing. Now, let's digress a minute and look at 4A, 3666-4A. Only one hearing shall be required. Now, we require an application for rezoning. We require an application for a special exception. We require an application for a variance, and all of those are separate applications. How many hearings are we supposed to have?
One.
Minimum one.
It says one. We have been having hearings, and I don't think that this is wrong either. We hold a hearing on the special exception, correct? We hold a hearing on the zoning. We hold a hearing, quote, a hearing, on the variance. What do we usually do in that case?
Item.
Yeah, vote.
We will have you consolidate them for purposes of the hearing,
Right.
but we make you vote on them separately.
Right.
Now, is that correct procedure under these new rules?
Doesn't look like.
I have no idea. All right. All right. It will be correct until a court of competent jurisdiction tells us that we're wrong, but we're not trying to circumvent the requirement. But now flip over and look at subpart G.
Before you go there, so
Yes, ma'am.
the question there is hearing. A hearing is to sound off the application, to hear the assessment by the staff
And the public comment.
and public comment. But it doesn't say the vote, it says the hearing.
Yeah.
So
And many jurisdictions will have a
results of the
hearing on
hearing-
one day and let the crowd go home and have the vote the next regular call meeting.
Huh.
Pike County does that.
Oh, yeah.
Lamar County does that.
Interesting.
Locust Grove, they have no planning commission. So they have a workshop at which the city council sits and hears it about a week before they have the council meeting where they vote. And
Jonesboro does the
technically
same
call
thing.
the hearing.
Jonesboro does the same thing.
So it's a workshop. All right, so a question then, so when we make our recommendation, the Board of Commissioners then, they hear the zoning, a special exception, and then the variance decisions we've made, right?
They hear your recommendations, yes, but they are the only hearing required under zoning procedures.
Right.
Your hearing, the authority for your hearing comes not from these statutes we're going through, but from the ordinance.
But then where I was going is on the variance, then whatever we decide at our meetings, did the Board of Commissioners then,
Have the ability to modify or accept your recommendation?
Yeah.
The answer is yes, it's treated the same way as a
Okay,
rezoning.
okay, then why is that considered quasi judicial if
It's
it's?
not.
Well,
It's not
it's
because
bundled
it's tied
together.
to the
Well,
rezoning.
yeah, I was gonna say, but one that's standalone, a standalone variance, then that's where whatever we say,
The final decision.
okay, all right, that's.
What's the difference?
Well, if it's coupled together, bundled in with another one,
The only difference is that the statute says if it's standalone, it goes this
Okay.
way.
right,
If it's part of the rezoning, it's legislative and goes with the rezoning or the special exception application.
well now, just for me, are we gonna get, is that gonna be like a separate, how will we know in the meeting? Will those all just be lumped in chronological order?
You've already had them. David puts rezoning, special exception, variance in order on the agenda. The only difference he's made recently was in Wallace Jackson, he put the variance first. And
Okay,
then
okay.
had special exception or rezoning and special exception.
Okay, all right.
Cause that, a negative on that would have killed the rest.
That's
Yeah,
correct.
yeah, I see, exactly, sure, okay. Just
That's
just
correct.
trying to process how that goes.
All right, so let's look at 3666-4G. A local government delegating decision-making power to a quasi-judicial board or agency shall provide a hearing on each proposed action described in paragraph 1.2 of Code Section 3666-3. Do y'all remember what 1.2 said? That's where they define a quasi-judicial decision as the exercise of quasi-judicial land powers, including hearing appeals of administrative decisions, and hearing and rendering decisions on application for variances, administrative permits, and other similar permits, not enumerated as a zoning decision. All right, so, even though, if you look at the hearing provision, back in 3666-4A, it talks about a hearing on a zoning decision. Subpart G says, if it's an administrative decision, an administrative appeal, you still have a hearing along the same rules. But, again, that hearing will be quasi-judicial. It will not be legislative. All right? Excuse me. Turn to 3666-5. B1, this is a brand new statute. It was adopted effective July 1st, 2025. We have, we still have some compliance stuff to do with this. Excuse me. But this added section B1. In addition to policies and procedures required by subsection A deals with zoning.
You need to go get some water.
If somebody's got some water, it'd be great.
I have some, but it might have a little kisser. You're welcome to it.
I'm sorry to take the water bottle, but I appreciate it.
Help yourself.
In addition to the procedures required by subsection A of this code section, each local government providing for a quasi-judicial boards or agencies grant or denial or review of a quasi-judicial matter shall adopt standards and criteria governing the exercise of the quasi-judicial decision-making authority. The policies and procedures, let's go to subpart C, the policies and procedures required by subsection A and the adoption of standards required by subsections B and B1 shall be included in and adopted as part of the zoning ordinance. Now, here's another place. Flip over to section 3666 5.1. Because this is a key distinction between the impact of when you act as a quasi-judicial authority versus a legislative authority, because it governs how you are appealed and how the appeal is handled. Let's look at A1. Zoning decisions, being legislative in nature, shall be subject to direct constitutional challenge regarding the validity of maintaining the existing zoning on the subject property or the validity of conditions of an interim zoning category other than what was requested in the Superior Court pursuant to its original jurisdiction. When a rezoning application comes to you and it seeks C2, David can confirm C2 is a pretty heavy commercial / light industrial district.
Wide open.
Are you required to deny the application if you make the determination that C2 is not appropriate?
Required?
Required. The answer is no. Your obligation is to assign to the property a constitutional zoning classification.
Which you're entitled to if you're not required. Am I right?
Right, you do not have to, you are not bound by the zoning district sought in the application. You just had a case that involved a history with that. It was the property at Teeman and 155 where they proposed to have a convenience store. That property had been the subject of an application 20 years ago to move from AR to C1 for a convenience store. Almost identical to what you heard. That application was granted to C1A, neighborhood commercial. Under the belief, now this is pre-village node and all that kind of stuff. Under the premise that C1A with more neighborhood commercial uses was more appropriate for that corner. There were a number of reasons for that. Number one, I don't know that Sun City existed. It might have been in process. Frank, do you remember a young lawyer named Chad Torrey who worked with us years ago? Like Stephen, Chad left us to go to a real law firm. And,
You're as real as they get, and I don't want anybody to dispute that.
I'm sorry?
You're as real as they get, and I don't want anybody to dispute.
He had that application for Smith Gambrell Russell. He worked for them, the same law firm that Kirk's working for, Kirk Felser. And he also had the property at Highway 19 and, 1941 and Bertie Road, the northwest corner. Both of which, the corner property at Teeman wound up in litigation. But no, you're not compelled to grant or deny C2. Your obligation is to zone it to a constitutional class. All right. Now, keep going in section 1. We've just said that it can be heard in Superior Court. Such challenges shall be by way of a de novo review. What does that mean? Pardon me? Okay.
It's a term I do not understand.
Well, it's Latin.
No speak.
It's Latin. It means new.
Okay. Of course.
De novo, new. So, for all of the hoopla we go through, and you have to sit through in terms of the public witnesses and the stuff that's presented to you one way or the other on this. And then the same is done in front of the Board of Commissioners. The Superior Court starts fresh when they take an appeal. Now, if you keep reading this section, it says such review brings up the whole record from the local government, and all evidence shall be, and all competent evidence shall be admissible in the trial thereof, whether adduced in a local government process or not. So, for example, let's look at the McElroy case. We go through hearings and hearings, and finally they make a decision to deny. You heard all sorts of testimony here regarding the comp plan, regarding traffic, regarding all of these other factors. Yes, that goes up to Superior Court, but you can bring in whatever you want in Superior Court. You're not bound by what is heard on or in the rezoning. And remember, a rezoning is what type of action?
Legislative.
Legislative. Now, let's look at subpart B, A2. Quasi-judicial decisions shall be subject to appellate review by the Superior Court pursuant to its appellate jurisdiction from a lower judicatory body, and shall be brought by way of a petition for such review as provided in Title V. Title V is the appeals title of the official code of Georgia Advocating. Such matters shall be reviewed on the record, which shall be brought to the Superior Court as provided in Title V. What does reviewed on the record mean?
Looking back at what has already happened.
That's correct. So under these statutes, the person who's coming to you for the variance, standalone variance, the person who is coming to you to appeal David's decision, you better stand up here and present everything you got. Because a review on the record means you're not going to be able to present anything new in the Superior Court. All right? Now, we experienced that on the demo permit appeal and the plat appeal. And we had to develop a record. Both sides had to develop a record because that applies to the county as well.
You speak in the microphone just a little more, I'm sorry.
Sure. That applies to our side as well. And if we had not done and asserted certain arguments in response to the demo permit appeal, we would be barred from raising them in Superior Court. All right? So, when you are sitting here reviewing an appeal from David's decision, you are the final arbiter of that case before it goes to Spalding County Superior Court, and it will go up only on a record of the material and evidence that you heard. Now, at the same time, Frank, you sat on plenty of variance cases. How many times did you ever have somebody come in with affidavit testimony to support their side of the case?
More than I care to remember.
Well, I said formal affidavit testimony.
No,
Never occurred.
never.
Now, if you're the applicant and it is a quasi-judicial decision, you better have your case prepared. Yes, sir.
All right, so, but anybody going to the appeals board prior to that, were they aware, is that a new provision in the law, or has that always been there? It's just, we
No.
have to see that now.
No, it hadn't
Oh.
always been there.
Oh, okay, all right, so,
But the last two appeals, and Bill, this was interesting because the last appeal we had to the Board of Appeals from a decision of the zoning administrator was probably 15 to 20 years ago.
oh, okay, okay.
Now they are accelerating. Okay?
Right,
I don't know if that's a good thing or
They-
a bad thing.
They have matured and they are reproducing. Okay?
everybody's upset, yeah.
I have never seen anything like this. If the case involving 5 Whitten, which was the subject of a land disturbance, I think it was land disturbance that you denied, which was scheduled for
Tomorrow night,
night.
but I was not.
If that had been held, that would be the third appeal.
Fourth.
That's correct, or technically fourth, yes. That would have been the fourth appeal in 8 months. And we had not had any since probably before 2010.
So then going back to like the variance with the Norcold. So the applicant had to have everything right there to be part of that record then.
Had you denied it, it would have, and had they had to take it up on appeal, then yes,
Okay.
whatever they needed
Right.
to support the variance, just like whatever would be needed to challenge David's decision, has to be presented here.
But I assume all attorneys representing the applicant are well aware of this, that they gotta give it their best shot for a variance, right?
I don't think you can presume that.
Okay, thank you.
I write my staff reports like there's a lawyer, or I assume everything is going to court.
Yeah, no, I'm not worried. I was
Alright.
trying to think of the other side of.
Yeah.
So,
Now, I
okay,
want to-
got it.
I want to highlight another distinction of when a case between legislative and quasi-judicial makes it over across the street. Go back up to subpart A1. And it says, this is about halfway down the paragraph, beginning in the sentence, such challenges shall be by way of de novo review. Such review brings up the whole record from the local government, and all competent evidence shall be admissible in the trial thereof, whether adduced in a local government process or not, and employing, and this is the part I want to highlight now, employing the presumption that a governmental zoning decision is valid and can be overcome substantively by a petitioner showing by clear and convincing evidence that the zoning classification is a significant detriment to the petitioner and insubstantially related to public health, safety, morality, or welfare. This is a brand new standard. Any local government has always had a presumption that it acted in compliance with the law. And in compliance with the law in a zoning case means you are allowing them the constitutional use of their property, and in Georgia that means they have reasonable economic use as zoned. All right. But here, the burden has increased on the applicant. Because keep in mind, the applicant's going to be the only person that takes a case up on appeal, and that's going to occur after they are denied.
Sure. Right.
Right. So, clear and convincing evidence. Now, that is a relatively new standard. It's not a new standard. It is a new standard, to my knowledge, being applied in the context of a zoning decision appeal. Now, excuse me. So we've got what the standard is for a zoning decision. Let's look at what is the standard for review in a quasi-judicial decision. And I want you to look at D. An appeal, I didn't highlight this part, but an appeal or challenge by an opponent. I'm sorry, let me go back up. The standard for the appeal is not stated in A2. It doesn't say clear and convincing evidence. It says on the basis of Title V. Now, and we've got to see how this plays out, if in fact Georgia's Administrative Procedure Act applies to these quasi-judicial decisions, when they go to Superior Court, the decision is supposed to be upheld under an any evidence standard. Meaning if there is some evidence that supports the decision of the Board of Appeals, or previously the Board of Appeals, now y'all, you're supposed to be upheld. Now, we have not seen a case go up to determine what that standard's going to be.
But this is new, right? New wording.
It's since 22-23,
Okay.
and no cases have gone up on this. But I want you to look to D, because this governs what happens if someone unconnected to the application files an appeal. And let's read through this. An appeal or challenge by an opponent filed pursuant to this chapter shall stay all proceedings in furtherance of the action appealed from or challenged unless the local government from which or from whom the appeal or challenge is taken certifies that by reason of the facts stated in the certificate, a stay would cause imminent peril to life and property. In such actions, the applicant for the zoning decision or the quasi-judicial decision shall be a necessary party and shall be named as a defendant in the action and served in accordance with the requirements of Title V or Title IX, which is the Civil Practice Act, as appropriate. So this allows a third party who's not an applicant to potentially come in and make a challenge. However, Georgia law does not allow that person to become the code enforcer in court. And they have to meet a stringent test called the substantial interest aggrieved citizen test to
Is this what's
establish a
occurring
viable
with
claim.
Wallace Jackson?
Pardon me?
Is this what's about to occur with Wallace Jackson?
This is what's happening in Wallace Jackson because two different lawsuits have been filed on Wallace Jackson by neighbors and people located far away,
They were not the applicants.
not the applicants.
Yeah, how does that jive when they're far away?
The standard is under substantial interest aggrieved citizen test, David. Again, this is public knowledge. This isn't something peculiar to this case. The person who is bringing the challenge has to establish special damages. In other words, their property, their interests are impacted uniquely, not just because, like every other citizen.
That's hard to do when you're across the county.
Well, we'll see how some of that plays out.
I've always wondered, not to get off on a tangent, but I'll be quick. With a DRI review, couldn't other governments use that to block something in another government they're asked to review?
Potentially.
That's kind of weird.
My problem with the DRI review was because you already had hearings scheduled on Wallace Jackson, and then suddenly they come in and say we've got to do the DRI. All right, what if the DRI held up the hearing that had already been scheduled? All right. The DRI folks are not going to have responsibility for that, but the county would potentially get blamed if something happened to contracts or other development things later. And then Three Rivers would just, oh, it's not, sorry, hate it. Okay, it's not our problem.
But aren't the DRIs issued as advisory and then they leave it up
Yes.
to the local?
Yes.
Yeah, they can.
The reason being that DCA and the respective regional commissions do not have zoning authority.
Which I'm not gonna say, I'm not gonna use the word useless, but, maybe a milder
They're
word than that.
advisory.
Good information, good information.
All right. Now, if you would now, I've got the
Glad
ordinance
You
that,
wouldn't have to do one of those impact statements.
I've got the ordinance that was passed back in November, or November or December, I don't remember which day, what month it was. And if you would, this is directly from David's record that you get. If you would, turn to page 560, because this says,
560, okay.
page 13 of the ordinance. When we deleted Appendix C in the Board of Appeals, the deletion of Appendix C was easy. But we had to go back and find where Board of Appeals was referenced. And we had to do substantive revisions, not really substantive changes, but we had to try to identify every place where Board of Appeals appeared in order to change it to Planning and Appeals Commission. I thought it was cute that you would be called a PAC like you're raising money for
I'm
politicians.
just gonna ask about that, so
You're a
we have
pack.
no ability to do that then.
You're a PAC. It's like when, we had to do the zoning, had to do the zoning to allow Sun City. Ms. Upshaw will appreciate this. We had it zoned for a planned development for a single-family residential development, either on a lake or a golf course. All right, and Fayette County had turned down Pulte, and Minerva had that property zoned, so Pulte called Minerva and said, can we move this to active adult residential? So, we had to do a new zoning class, and I wanted to call it active adult residential dash planned. So they would be AARP. They would not let me do that. All right. However, that was in 2003 or so. All right. We were the only local government that had a zoning district that said AARP. All right, let's look at 410 because this governs what you would have heard tomorrow night. Appealing a decision of the administrative officer or building official. The appeal, first in A, the appeal must be filed within 30 days of the date on which the action by the administrative officer or building official was issued. That is a standard provision. So, David, I don't remember what day you would have told Mr. Paul Hoos that he couldn't get an LDP, but
It was in November something, and he filed exactly 30 days later in December.
okay. All right, and then the Planning and Appeals Commission has jurisdiction for hearing appeals concerning decisions of the administrative officer or building official. All right. When a decision of the administrative officer is appealed, all construction, this is C, all construction or other contested activity authorized by the appeal decision must be stopped immediately. And then, David would have some leeway to make a judgment call as to whether it continues. So in such cases, construction or other activity authorized by the appeal decision is allowed to continue unless the construction is halted by the Planning and Appeals Commission or a restraining order is granted by a court. Then you have the provisions for you to have your hearing, which would have been scheduled tomorrow night. Now, and that's at least 30 days before the hearing. Now, that came from a provision of House Bill 1405 that somehow set different notice dates and hearing dates between a zoning decision and either a variance or an appeal. That has now been corrected, and to be honest with you, we've got to go back and do yet again a little more cleanup to now come back into compliance. The commission will make a decision concerning the appeal and record the decision in the minutes for that meeting. Any person aggrieved by a decision by the commission with respect to such appeals described in this section may petition the Spalding County Superior Court for a writ of certiorari and review of decision. That also has now, the writ of certiorari has also been eliminated as a requirement for appeal. So like I say, even though we're having to change and do continuing modifications to these ordinances to keep us as close as we can in compliance with state law. So, what would happen tomorrow night is we would conduct the hearing. And remember what I said, this is a hearing that will establish a record, not just for your decision, but for any appeal that goes forward. So the plaintiff would stand up, not plaintiff, I'm sorry. The applicant would stand up and tell you and present evidence as to why David is wrong. And then David would stand up and tell you why he has always made perfect decisions. All right. All right.
And then I would challenge them to a duel.
All right. Now, you do not and will not take testimony and comment from the public.
Oh, okay.
No. This is a legal issue between the applicant who says David made a bad decision and David to support what he says is a good decision.
But that's the appeal, correct?
It's here in front of you
No, but I mean, that's
with the appeal.
the avenue, it's where they said we were wrong for these reasons.
Right.
Okay,
Now, you do not have that, you will not do that when you have a standalone variance. It will
Correct.
proceed
Correct.
just like New Code did,
correct.
okay? But this is a very special and relatively unique, even though we've had 4 in a year, process that, for example, even though the Board of Appeals has had that authority since the Board of Appeals has existed, we had to teach them, just like we're walking through it with you, when the issue came up regarding the forklift graveyard. Nobody on that board had ever sat through or heard an appeal.
But now, would those be listed as part of our regular agenda items, Newton?
Right, the appeal
Okay.
hearing would be listed, yes.
Okay, and is that in order of how they're processed, or is it gonna be like broken out? I mean,
I had it for almost last,
okay,
but I wouldn't never put that in the middle. That'd be weird. It'd either be first or last, probably.
Would your public announcement have to be published to say, this is the public hearing, and then except for that number, whatever that one was, would it be separated to indicate that there was no public input?
You would have to make an announcement at the beginning
That
of
was
that
just
hearing.
simply an announcement, not in the public,
Correct.
advertisement.
And that is,
So I've been advertising them just like any other thing.
right,
Yeah,
the advertisement's
make an
different from the
announcement,
actual rule that comes
Well, I
here.
guess that's what I was asking.
you
Did
would
it
have to make an
require
announcement
a special
during-
advertisement?
No, it doesn't require special advertisement, just has to require notice of appeal, a hearing on the appeal. That's all the advertisement says. But we have made announcements in the last 2 before the Board of Appeals that no public comment would be taken.
and then I guess too, there wouldn't be any sign-up sheets out there for that,
No.
right?
Not
Not
for
for that one,
thing.
no.
So no one would really know to look for it unless,
Right.
okay. I'm just trying to make sure
Right,
I'm
well,
aware
that
of
was
it. when it
basically,
comes up.
my input was that people will read that and they will glance at it and see it's something that's of interest to me. I've been to other meetings that have been advertised. I know I get to speak because I can come to a public hearing. And unless it's itemized that it is not to be a public input, then it seems that we would run aground here in this room at that time.
Couldn't you do that in the publication?
I mean, you could, but it's not necessary, Frank. It's easier. I mean, for example, when the McElroy appeal on the demo permit and the plat were heard, you had a full crowd. But William Slaughter, we had him make an announcement that as to how the appeal was going to go. And, okay. Now, I have had a circumstance, this came up in Upson County, where they let people talk. And I think that was error. And it's in my appeal to Superior Court. Okay. But trust me, there were other, in my view, other things more significant. But nonetheless, I think it was, they have however, they have an ordinance provision, if I recall correctly, that had that and allowed them to do it. but we are not relitigating a zoning case in order to address an allegation that David's office has made an error of some sort. You couldn't do it. And what you can see, I want to raise this with you so you can see where this is going. Compare what we're talking about in terms of the format for the hearing, that if it were held tomorrow night, or the hearings that we had on appeals from David's other decisions. Compare that to the rezoning application hearings that we have. All right? The rezoning application hearings have virtually no structure. People just say whatever they want, irrespective of truth. All right? They make any allegation that they choose. But, I mean, and past the point, it is their right to do it, but I will say one thing I said in a Pike County hearing one time is that I would stand up and support anybody's right to speak on any publicly filed application that required governmental review or governmental approval. But corresponding to that right is the responsibility to be prepared, not make ridiculous accusations, and respect the factual circumstances of the development. Okay? In that case, the fellow wanted to pull spring water out, and you had people stand up and say, it's going to cause the Flint River to go dry. Okay? And we've heard foolishness up here. My favorite that I've told David is when the Buddhist temple was first up. This was 2004 or 5. We were told that the burning of incense would cause the fella next door's cows to go sterile. All right, I don't think that's likely to occur. I mean, and y'all have heard things like this. I mean, so what we're moving to, what I can see happening, though this will probably not occur while I'm still in practice, but what we are moving to is essentially having a procedure that looks much more like a real hearing. All right? And of course, the trade-off for that is going to be, you can get this done, you can get a rezoning hearing done, even if we have a large crowd to speak. You can get that done and make a decision within a reasonable period of time. And y'all don't have the time as a volunteer board to sit down and listen to what would effectively be judicial cases. Now, we have some people on the Supreme Court, Georgia Supreme Court, that have suggested that's what should be done. And they almost a couple of years ago issued an opinion that came very close to saying that rezoning was quasi-judicial. And if that had been the case, you can see what the impact of this would be. Your challenge is to recognize which hat you're wearing in which context while you're here. Now, we are not going to prevent people from talking on a variance. All right? We are safe, in my opinion, preventing public comment on a true appeal. And I will close, Bill, with a case that you were involved in that I think created your zoning interest. And that occurred around 1999 or 2000.
Malloy Road area.
Malloy Road and Florida Rocks expansion. And we were able, in that instance, at that time, my, quarry was allowed as a special exception in AR1. And special exceptions had not yet been identified as a zoning decision. So it stayed at the Board of Appeals. So the Board of Appeals had the authority to approve a quarry or the expansion of a quarry. And if you remember, we were successful in getting, thankfully, both sides had counsel. I think you were an opponent and y'all paid for Richard Hubert to come down. And David Flint represented Florida Rock. And we allotted 30 minutes per side. And I think everybody thought that that was fair. Yeah. What's wrong, Frank?
Well, I wanted to bring up the fact that, we have not been signing the, disclaimer, which we always did. I was the swing vote.
That was the thing where, you were asked to sign the contribution, whether you had received a contribution or made.
It's in the book, and I didn't know it was in the book, but we have never been asked to sign it. Not in the last, several times.
Well, I wanted to see what y'all were talking about, because I remember that, I think you were David Flint represented the outdoor sign industry.
Yeah, and
David had given you,
he had
you
given
ran
me
for
a
the State House.
$500 contribution because none of my business buddies would. But I made the statement that if anybody felt like it'd be bought for $500, let them hold their hand up, and nobody did.
Well, $500 went further back then, but,
We did.
But I remember that happening, and I remember that you had to report that. But at the same time,
Yeah.
go ahead.
I was just gonna, when I was on planning back in because I remember 1999, 99 virus stuff coming up. The world was gonna end. After every meeting, we had to sign a statement that something about no financial or vested interest, because I remember there was always a big signing ceremony.
And it's in the book.
All right, I'll double check, and
So
I'll
year
double check.
1999 or year 2000, Nancy Moon, I don't know, was way back then. That's
Right, Nancy was the
20
Nancy was the
25
first
plus years.
professional
right.
planning director
Right.
that we had.
Now, in the applications, there's a thing where they fill it out and say they didn't contribute to the Board of Commissioners.
Correct.
But
Correct.
Eva seems to remember one for the BOA, but not for this board, so I don't know.
I'll double check.
Because I was never on appeals. I was always on
You're on
the
planning commission.
planning commission way back.
See, shortly after that was when the legislature made special exceptions a zoning decision.
So I remember that's probably when Johnny Bolton became the millionaire, right? With the rock quarry.
Johnny was an interesting persona in the late 1990s.
Y'all
Yes.
don't realize James Kay and Darrell Boaz, I mean, they
James
actually
Kay.
defined what security at these meetings meant.
Especially Boaz.
Well, anyway, so
Anyway,
that,
yes.
do y'all have any questions now about if you get another appeal come up now that we have been through training on this, or what I consider training on it, I hope y'all have thought it was useful.
Very good.
We probably will not have another appeal for the next 10 years. That's the way this stuff usually works.
And I guess just so I'm, just for me, how will we know on the agenda, other than David would try to probably put it first or last? Will it be like an appeal, I mean, how will that be
He
shown
put, as
up in our
opposed to having a
title?
V or an S or a Z,
APP.
you put APP on it.
Okay, okay.
I think I've discovered your problem. Eva just said, we did it with Debbie, but after Debbie left, Brad and Kelly thought it was a waste of time, so I stopped handing them out.
Well, that answered that question, just like they didn't do, well, never mind, I won't say that on the.
We can come up with another one.
It's a CY, it's a good
But so we will
CYA.
most likely, as you mentioned earlier about the 30 minutes, so you would kind of look at what you're dealing with and maybe set a designated time for each side to go in and have their say.
Pretty much, Bruce, that's what we need to do. Like I told you, we still got some cleanup from this last statute to do, but look at all the work David's been having to do to get the zoning stuff moving forward. And, I noticed that Muni Code had codified
Yes.
the first zoning amendments dealing with 1405, which dated from 23.
Well, I'll tell you, the board thanks both you and David very much for all of the work you do.
Absolutely.
Well, you are, we're seeing more development applications than at any time since before the recession. And before the recession, it was residential, and this is now industrial and commercial.
Well,
And
thank
keep
you.
in- Bolton Parkway's been in place since 1998.
Yep.
And we had essentially no development. We got a little piece here and a little piece there, but essentially no development until the beginning of 25, end of 24, beginning of 25.
You know, one of the things that I've talked to, Brian Upson about is the fact that so few of those roads that spin off the Bolton Parkway were actually designed and built to handle the kind of traffic they're gonna be doing, and I don't know how we address that.
We do it in the zoning action and we make sure the applicant improves the roadway.
Well, the commission made the decision back then when they were gonna, because Bolton Parkway and the overlay roughly coincide in timing. The commission had made a decision early on that it would be limited access, and the people who needed access would be given those little cul-de-sacs to allow them to access to driveways along the side of the road. That prompted us to be able to say when industrial development occurred, we would require them to do frontage roads in order to make certain the subsequent people could get back and get through. And,
Yeah.
we have had that planned for an industrial corridor since that time. Wallace Road came a little later because there was discussion of an interchange at Jenkinsburg Road. But that also, had been zoned or planned for industrial, heavy commercial development, within just a few years after Bolton Parkway.
What has happened to that Jenkinsburg Road interchange?
That's beyond my pay grade. I don't know. David might know. I don't know what.
Heard is probably not gonna happen, but I don't know for sure.
I'm supposed to have lunch with, Dennis McIntyre next week.
All right, y'all do not have an appeal tomorrow night, but you do have you still have a heavy agenda. And what does BOC have Thursday night, David? Do they have much?
It's not too bad, no, some maps and, one other thing that's not too bad. Oh, the lifting of the, two Minerva things on Jordan Hill off
Gotcha.
the table.
Okay. So, all right, any further questions? Y'all okay with?
Thank you, because I wasn't
Thank you
sure
very much.
what appeals really did, so very, very interesting. Thank you.
Y'all will have both duties. And like I say, you'll have to be cognizant of the difference, and this will be reflected in David's respective staff reports. You need to be cognizant of the duty, the different duties that you have under both hats.
Thank you very much.
All right, we'll see y'all tomorrow night.
Okey doke.
Thank you.
Do I have a motion to,
So moved.
Second?
all in favor, raise your hand. All opposed? There is no opposition. This meeting is adjourned.
All right, thank you.
Hallelujah.